It should be in there. It seems to me very odd. I'm not claiming any bad faith on the state's part, but it seems odd that Hennepin County Medical Center, when they're asked to turn over all their records, that they don't include records that maybe are just buried a little deeper. I think their response to the subpoena was probably insufficient in and of itself. And they should check their standard operating procedures so that in the event this happens again, that they will supply all the information they have. But in any case, the defense gave notice that this was going to be an issue and specifically talked about testing the sample. The state had sufficient time to investigate and disclose to, even if it's just because Dr. Baker called the state and said, we can actually find this, at 8 o'clock this morning, when the state is, or the defense expert is done testifying, has left the state. It's untimely to give the notice, and it prejudiced the defense by the late disclosure, even if it's not due to bad faith. But the late disclosure has prejudiced the defense. It's not going to be allowed. So Dr. Tobin will not be allowed to testify as to those lab results. If there's anything he wished to add about carbon monoxide as far as environmental factors, but if he even hints that there are test results that the jury has not heard about, it's going to be a mistrial. Pure and simple.
Do you have an opinion to a reasonable degree of medical certainty as to whether this statement that Mr. Floyd's carboxyhemoglobin could have increased by 10 to 18% is reliable?
No, I believe it is not reliable.
Would you tell the ladies and gentlemen why that statement is not reliable?
I base it on the arterial blood gas that was obtained when Mr. Floyd was in Hennepin County.
Please sidebar. I think the objection should be sustained, but just rephrased.